Nice to see everyone again. Welcome back to Civil Procedure. Hope people are doing well. So last week we were talking about cost awards. So cost awards, people hopefully recall, this is the extra payment that a court can require a party to make after the conclusion of civil litigation. And it's a payment which compensates a party for what happened during the litigation and for the very fact that litigation was necessary to uphold their legal rights in the first place. So we had a few questions, participation questions here, a couple kind of tricky ones about this. Why don't we just go through this and look at some of our slides as well to review costs. So cost awards do many different things, and they can take many different, produce many different numbers. But it's important not to lose sight of the fact that the most common garden variety cost award will be this second one here. The unsuccessful party paying 50% of the successful party's costs. That's like cost shifting, right? The loser pays system. The rest of this stuff comes in. So there's no particular reason why it should be the plaintiff paying the defendant any more often than the defendant pays the plaintiff, right? Costs go both ways in our system. And these other things here can happen, but this is the one that's going to be the most common cost award you see. Okay, item below, which does not reflect any of the goals of cost awards in Ontario Civil Procedure. And there's lots of things going on, but this is not one of them, right? This is what we use damages or other judicial orders to resolve. So the lawsuit itself happens, the lawsuit pertains to things that happened in the real world where the litigation began, and then the verdict and the judgment will again refer to what happened in the real world and perhaps order damages to compensate for that. Costs are about what happened in the litigation itself, or about the fact that litigation was necessary in the first place. So I hope that distinction is reasonably clear. So this is part of the cost goal. Maybe people just type in if they remember what the word is we use to describe this whole idea. Yes, excellent. People got it. Proportionality. That's what this is about. And we do that in cost awards. Maybe I'll call back up this slide, a pretty important slide that kind of summarizes the things that are going on in cost awards, the different policies, different goals that a court will pursue in making a cost award. And the way proportionality will typically come into it is that if a party who would otherwise be entitled to costs and is in fact entitled to costs, if that party has spent more money or over-lawyered the case relative to the significance of what they're arguing over, then the proportion of their costs that they're going to get back from the unsuccessful parties is lower than it would otherwise be. So that brings us to the end of part one of the course. So we've gone through the conventional civil action from pleadings all the way to the cost award, and we've seen many virtues of this. We've seen how it works. We've seen the lengths the system goes to try to be fair and make sure that all sides are heard. But we've also tried to emphasize how costly and time-consuming this is, and how inflexible and limited our civil justice system would be if this were the only game in town. If to assert any type of civil right on behalf of a client, you had to walk that client all the way up the long and winding road. Hence, part two of the course, right? Other routes to civil justice. So these are all the legal mechanisms that you have at your disposal to protect your client's civil rights without having to conduct an entire civil action from beginning to end. Now, most of these are in the rules of civil procedure, right? So they're just sort of black letter as the conventional civil action is, and we're going to look at them from a policy point of view in terms of why they're in the rules of civil procedure and how they respond to the deficiencies and shortcomings of this. But then we're also going to try to think about them strategically, right? How you can deploy these mechanisms to advance your client's interests and create a happy client. Okay. So the first one of these is disposition without trial. So these are today's slides now. So disposition. So disposition is a fancy way to say ending, right? And so these are all different ways to end a civil action without having to go all the way to trial. From the lawyer's kind of strategic point of view, disposition without trial is an opportunity to get a total win for your client at an early stage, right? So, if your client, if you imagine going to trial and winning completely on behalf of your client's happy, but your client is vastly more happy if you manage that same total win without having to go all the way to trial. And that's why lawyers get excited about disposition without trial, because it's a relatively cheap, relatively early, but total win. From the system's point of view, we have disposition without trial because given the concern for proportionality, there are ways to be sure enough about what justice requires without having to go all the way to trial. Now, I'm going to take us back to a slide you've seen already last month, our family tree of motions. So motions, people recall, are any request for adjudication short of a trial or an appeal. And all of these disposition without trial techniques operate through motions, right? You bring a motion to obtain any of these remedies that we're going to be talking about. And we're going to talk about 8 of them. 8. Used to be 7. This is a newcomer. So anyway, let's just say 8. We have so all of these are going to be ways to secure that cheap, early, complete win for your client. And hopefully we'll get through the first 4 of them today. All right, so the very first one is striking pleadings without leave to amend. So pleadings, you remember we started the course by talking about pleadings, right? The statement of claim, the statement of defense, the documents that parties to a civil action issue in order to define the scope of the proceeding and set the stage for hopefully a voluntary resolution. And striking pleadings is a disposition without trial mechanism you can use if your adversary's pleadings are so problematic, so inherently deficient that having an action about them is unnecessary and wasteful. And so you've got a couple of rules that talk about this idea. Rule 25.11, the court may strike out or expunge all or part of a pleading or other document with or without leave to amend on the ground that the pleading or other document A, may prejudice or delay the fair trial of the action, B, is scandalous, frivolous, or vexatious, or C, is an abuse of the process of the court. So this is used. We'll talk about B first, right? So a pleading can be scandalous, frivolous, or vexatious if it is simply designed to damage the adversary's reputation, right? Sometimes people will sue each other for basically PR purposes without a legal merit. Yes, Kamal's got it. You've anticipated my next question. This is what Jian Ghomeshi did. right? So you remember this? This was about a month ago, where Jian Ghomeshi was fired by the CBC, and he very quickly brought this claim that asserting that they had wrongfully dismissed him, and there was some weird invented tort in there that he was alleging against the CBC, and it effectively emerged that there was no legal merit to this. He was just trying to kind of change the media narrative and get himself in the position of a victim as opposed to, alleged sexual predator. So that was a motion. That was a statement of claim which was struck out. Right, the CBC brought a motion to strike it out. It was never adjudicated because he just dropped it as soon as that was brought about. So this is used where the motive of the pleading party is wrong, right? They're not using the system for what it's meant to be used for. So if a judge is hearing this motion to strike out a pleading or another document, they can reject that motion and let the pleadings continue. They can also strike it out completely. But there's also a compromise, right? They can strike out or expunge all or part of a pleading with leave to amend. So, and of course, if it's struck out with leave to amend, then it's not disposition without trial, right? At that point, it just becomes a matter of that party having to go back and amend their pleading, so it's no longer crosses any of these lines. Okay, so the other rule, and these rules are sometimes pled together. Like often, if you're trying to strike out pleadings, you'll rely on both Rule 25.11 and 21.01 sub 1 sub B, right? The line between these is not clear. As you've no doubt observed in the rules of civil procedure, it's not drafted logically. It's like archaeologists will dig up these ancient dumps, right? This is how we learn about vanished civilizations, by going through their things they threw away in many cases. And when they do that, like you'll uncover layer after layer of garbage in the dump, where 10,000 years of history is represented by different layers of broken pottery shards or whatever. The rules of civil procedure are kind of like that, right? Like there were original rules somewhere back in the midst of time, and then every 20 years something kind of some more stuff gets laid on top of it, but nothing is removed, right? It's very seldom anything's removed. So often you'll find that are basically about the same thing, but they're both still there because it's hard for them to remove anything. Because old lawyers get used to relying on the old rule, right? And then someone comes along and says, oh, we need a new rule to deal with these new cases. And they sort of grudgingly say, okay, well, that's something new to the rules, but we're certainly not going to take out this old one that we're all used to. So the consequences, they're both there, and we have to try to tease out what, if anything, the difference is between them. Anyway, that's beside the point. Okay, so this is the second important rule here, right? Okay, so David asked, what falls under the definition of or other document? Yeah, so technically this can be used to strike out things other than pleadings. And so this could be used to strike out and like an affidavit or something along those lines. We're not going to get into that. Like for present purposes, we're talking about striking out a pleading, which is a way to actually end the case, secure disposition without trial. Okay, so this says that a party may move before a judge to strike out a pleading on the ground that it discloses no reasonable cause of action or defense, and the judge may make an order or grant judgment accordingly. So Dawson versus Rexcraft is an important case that kind of explains what this is all about. And the key phrase here is substantive adequacy, right? That statements of claim, or statements of defense for that matter, have to be substantively adequate in the sense that they articulate a set of facts which, if true, would entitle the pleading party to the legal relief that they are claiming. When a pleading lacks substantive adequacy, it is subject to being struck out. So they give this this classic example here of someone bringing a lawsuit about something that the law takes no notice of, right? So I'm offended by the color of someone else's car. You sue your neighbor because they're actually an alien who destroyed your pet cat, right? There's just nothing to it, right? Either it's so utterly fanciful that it could never work. I take back that one about the alien, because I think if you could prove that, it would be substantively adequate. Let's stick with the Dawson example, right? The thing about the color of the car, where this one here, right? So it doesn't matter whether you can prove it or not. It doesn't matter what the facts show. Taken at its best, the plaintiff's claim is not referring to anything that the law cares about. So, we have to bear in mind here that the common law is always capable of evolution, right? And many of the things that are now absolute standard black letter law were at one point considered fanciful and outside the bounds of what the law cared for. For example, the whole idea of negligence, which did not exist 80 years ago, and then it was invented in Donahue versus Stevenson. So that's there, right? So courts are going to be reluctant to strike out pleadings on this basis. But if there's no way you could possibly win, then they're going to strike it out. And the reason for that comes back to costs, right? And to avoiding the necessity of having parties spend time trying to prove things which can never yield any legal remedy, even if they are completely proven. Okay, so a pleading can be substantively inadequate in that sense. A pleading can also be substantively inadequate in the sense that it lacks the material facts to support the claim. Right? So we know that all pleadings have to include the material facts that add up to the remedy being sought. And if they're not pled, then the pleading is substantively inadequate and can be struck out. So all this hopefully explains why no evidence is admissible on a motion under this clause, right? Because you only want to use this when there's a problem with the pleading, which is evident from the words of the pleading itself. We'll see we have other techniques for disposition without trial when there actually is a factual or evidentiary dispute, but that's not what this is about. Okay, so Dawson also tells us at paragraph 9 that a court is required to give a generous reading to the statement of claim, construe it in the light most favorable to the plaintiff, and be satisfied that it is plain and obvious that the plaintiff cannot succeed. Because the plaintiff, at the stage of the pleading, has never had a chance to provide evidence. And we're not going to deprive them of the ability to do so unless that standard is met. So the Maguna case shows this at work. So Mr. Maguna was charged with sexual assault. He was arrested in a peculiar way, right? The police have great discretion about how they're going to arrest people. They can sort of arrest them in a very public, embarrassing way, or they can arrest them in a much more discreet way, assuming they're not resisting arrest. So he faced these charges. What happened to the criminal charges against Mr. Maguna?
think I remember it said something about the two women had like inconsistent testimonies, or like their stories weren't really straight or something like that. And in the end, he was acquitted of the charges.
Yes, yes, that's right. That's right. So, so he was acquitted, uh, and after he was acquitted, he brought this lawsuit forward against the police and against various defendants within the government of Ontario. So, and the allegations he's making, resonate with very significant evidence we have of the fact that police discretion seems to be applied in a way which is racially discriminatory in many cases. In this case, it's not about who gets carded or who gets charged, but rather about how people are charged, right? And evidence of racial disparities in terms of the way those decisions are made. Okay, so Maguna sues the Crown, attorneys, the police, and the Queen, and the Attorney General, and Legal Aid Ontario. The core suit is brought in malicious prosecution, which is a tort which is available to people after they've been charged with crimes but acquitted in certain defined circumstances. So he brings the statement of claim, and the defendants move to strike it. Okay, so so there's an interesting statement of paragraph 9 where he says, the judge says, the facts as pleaded in the statement of claim must be taken to be true. So what is up with that? I mean, plaintiffs bear the burden, right, on a balance of probability to establish their claims. So why are we now taking them as true? Okay, yeah, I think people are coming close to it here. So Rhiannon says you can't bring evidence in the statement of claim. So we have to assume it's the facts. Yeah, so it has to do with the stage we're at, right? We are at the early part of litigation, where the pleadings, where we have not yet got to any discovery, right? So no one has had a chance to lead any evidence. And in the normal course, the parties are going to bring forward their evidence, and only after evidence is forthcoming are we going to make a determination. This is an exceptional remedy which is available to strike out pleadings at an early stage when they're really, really obviously deficient. So to use this exceptional remedy, we have to give the plaintiff the benefit of the doubt. We have to say, we're going to assume everything in there is true and see if we can dispose of it even on the basis of that assumption. Okay, so some of this is struck out. So right, so the action against Her Majesty the Queen. So this is a nice little example of how striking out pleadings can work, right? This act gives a very explicit timeline, right? No action may be commenced against the Crown without 60 days prior notice having been given, right? This is something to bear in mind if you're suing any type of government defendant. Often there will be special rules that require you to either move more quickly to sue them than you would to sue a private defendant, or give like a notice requirement here, right? You got to wait 60 days. You have to give them notice. We won't talk about the notice giving process, but anyway, the point here is that there's a very explicit statute which says that you have to let the 60 days go by, and quite obviously, only 12 days passed between notice being given and the statement of claim being issued. So even assuming every single word in the pleadings is true, it simply cannot succeed. So that's struck out completely. Okay, now in terms of Maguna's other claims, it's a little bit more complicated, right? So paragraphs 10 to 12, we get a review of this malicious prosecution tort and the negligent investigation tort, which he's also pleading. The mere fact that you've been prosecuted for a crime, charged with a crime, and were exonerated is not in of itself sufficient. You've got to prove some extra facts here. And then in paragraph 13, the issue is whether Mr. Maguna's statement of claim discloses permissible causes of action against these defendants, or whether, if leave to amend is granted, the statement of claim could do so. So it's clear that the judge is not impressed by the pleadings. So there's too many different torts being pled. There are 16 to 25 separate kind of causes of action listed in the pleadings. There are too many adjectives and adverbs in it, right? It just basically doesn't satisfy all those rules of good pleadings that we looked at. All that being said, this claim is not completely without merit, right? The statement of claim does contain some basis for alleging the core causes of action that are asserted. So, so judges are going to, if there's problems with it, they're going to try as best they can to identify the claim that could be there and that could be upheld if it were properly pled. So there's evidence of that he was racially profiled. There's evidence that the Crown really should have dropped these charges earlier than they did, and some evidence that the Crown, I shouldn't say evidence, because there is no evidence at all yet, right? But there is there are claims, cogent claims, which could be proven that the Crown did all these bad things, right? And tried to maximize bad press for Mr. Maguna is another one of them. Okay, so the motion judge dismissed the pleadings. They are overturned here by the Court of Appeal. And says that in cases like this, you have to defer to the pleading party, right? You have to assume the best of the pleading party and take what they say to be true and look for the potential grains of truth in the plea. And if you find those potential grains of truth of legitimate claims, that doesn't mean you accept deficient pleadings, but it means you give the pleading party another chance. You strike them out with leave to amend, right? Which means that it's not disposition without trial. It becomes just sort of a procedural motion decision where they get to go back and try again. We've seen judges doing that before, right? In Copeland versus Commodore, with the motion for particulars, and also with McDonald and Ross with the defendant who left out their arson claim, right? So pleading parties, that's the sort of a more standard, much less drastic remedy is to say, yes, we're striking it out, but go back and try again. A drastic remedy is to say we're striking out your pleading, which means you lose right now, forever. That's what the motion judge wanted to do to Maguna. Court of Appeal says that is an overreaction. So paragraph 24 is, I think, really the takeaway. The test is whether, where was it? The test for granting leave to a pleading, assuming the pleading is bad enough that it has to be struck, and the question becomes, do we grant the leave to amend or not? The test for granting that leave is not whether the pleader should be punished for previous misstatements or for making serious but bald allegations. Rather, the test is whether the amendment can properly be made without prejudice to the other side. Prejudice, people recall, means unfair disadvantage to a litigant. And, unquestionably, there's some disadvantage to the other side, right? The Crown defendants would have been better off if Mr. Maguna had drafted proper pleadings initially, and now that he has failed to do so, the Crown defendants would be better off if the case were struck completely. So there is prejudice, but what do we do with prejudice? What do courts do to remedy this type of prejudice? Like a disadvantage or an extra cost or inconvenience faced by a litigant. Right. Yeah, Catherine's got it. So additional costs at the end, and this played to the bad behavior part of costs, right? Problematic behavior, and what Mr. Maguna did here is the exact sort of behavior that would lead to cost consequences. And then there's a few other tools as well, right? So adjournment, so parties can be given more time, for example, or given the right to examine someone again. The courts have many tools to deal with prejudice, and they're going to try to use those tools before they leap to the drastic remedy of eliminating someone's potential legal rights. And it comes back to this, right? I mean, we've seen this rule, right? This idea that the rules are liberally construed to secure the just, most expeditious, least expensive determinations. If we were to strike out pleadings without leave to amend, that would be a very inflexible approach. And among other problems, it would punish litigants for the failures of their lawyers, right? It's not my fault if I hire a lawyer and she drafts crappy pleadings, and yet you are foreclosing my rights permanently if you strike out my claim permanently without leave to amend because of the crappy job my lawyer has done. Okay, so I think that's all we'll say about striking pleadings. It's a good remedy to keep in mind, useful very early in a case. But it's a pretty rare pleading, which is going to be bad enough to let you do this. Okay, so we come now to the Hriniak case, a big, important Supreme Court of Canada decision, maybe the most important case in the whole course, because it tells us some important principles of civil procedure, which are applicable in various contexts and when looking at various rules. So it's a case about access to justice, about proportionality. It's about the sort of shortcomings and limitations of the conventional civil action, and about the place of the trial. Right, the trial has this kind of mystical power in people's minds, and advocates often fall into the trap of thinking of everything as kind of preparation for trial. And the Supreme Court of Canada is trying to get us away from that, and they're trying to give props to some of these alternatives, and specifically in this case, summary judgment. Okay, so Justice Karakstanis comes out guns blazing. First paragraph, ensuring access to justice is the greatest challenge to the rule of law in Canada today. And so how do we do that? Well, we need a culture shift, she says. And that culture shift, calling it a culture shift might be a little bit of an overstatement. The culture shift is about the way we think about pretrial procedures, the way we think about disposition without trial, and moving the emphasis away from the conventional trial in favor of proportional procedures tailored to the needs of the particular case. While going to trial has long been seen as the last resort, dispute resolution, okay, we'll get to that in a second. That slide will make more sense in a second. Okay, so the case is specifically about summary judgment versus trial. Summary judgment is the third of our 8 techniques for disposition without trial, and so that's like the specific legal issue that comes out of this. But the case Hriniak is also about settlement versus adjudication. So we know already that settlement is crucial, right? And 95% of litigants will settle their cases at some point. For most litigants, access to justice means access to a just settlement or a reasonable compromise. And then none of that's anything new, right? That obviously was not invented in 2016. But this is what's new, right? Going to trial has long been seen as the last resort, so we've known for a long time almost everyone settles. But dispute resolution mechanisms such as mediation and settlement are more likely to produce fair and just results when adjudication remains a realistic alternative. So why is that? I mean, it's kind of a counterintuitive paragraph, right? Because most people would say, okay, we got mediation and settlement over here, and then we got adjudication over here, right? And the message the rules generally send is we like settlement, which means we don't like adjudication. But here she's kind of saying something a bit more subtle about, and saying that adjudication, or the prospect of adjudication, in fact strengthens the potential of mediation and settlement. Can anyone explain that? I'd love to hear from someone, if anyone's able to raise their hands and kind of tell us what she's getting at here. Why are these two things that seem to be opposites, or seem to be kind of antitheses of each other, are kind of in a symbiosis?
Hi, Professor. Perhaps it's because having adjudication makes it serious enough that you would take settlement seriously and make like fair dealings, as opposed to not having it at all, and then maybe settlement would be like kind of a joke. People wouldn't take it seriously moving forward.
Yeah. Okay. Great. So why specifically would a litigant be more serious about settlement if they see adjudication as a realistic possibility?
It's kind of like the threat of something more happening, and it's telling the other party, like, I have the capability, and I have the capability of going further with this, but if we can settle it earlier, then that's fine. So it's kind of just like that extra ammo in your backpack in case you need it.
Absolutely. Yeah, that's exactly it, right? The threat, is there. If adjudication is a possibility, then the other party suddenly has a much greater incentive to come to the table because of their fear of adjudication. So that's definitely true. The other relationship here that's important is this idea of the shadow of the law. I don't know if people have seen this. Does this phrase ring a bell with anyone? The shadow of the law. It's not just that adjudication incentivizes parties to come to the table and negotiate for fear of what adjudication might result in. It's also that adjudication gives them certainty about what terms they should be settling on. Yeah, it develops the common law, as Jessica says. It's not exactly that it's overseeing you. It's that you know what the law is because of adjudicated decisions, right? So we have all these wonderful decisions, and you've been reading them for 2 years now, right? They let us know what the law is, and they let settling parties know what the law is. So there's a sense in which settling parties are kind of free riding off the parties who litigate, because if it weren't for poor Mr. Riniak and Mr. Malden, right, who spent $400,000 of their money and years of their time, if it weren't for them, then we would not have the benefit of the decision Riniak versus Malden. And we wouldn't be able to learn from it, and litigants would not be able to look at it and say, oh, so that's what the law is. And now that I know what the law is, I don't have to spend $400,000 in 3 years. I can just settle now. So that's the other part. The common law develops, and the decisions, the law itself, create this shadow, and then you can like locate yourself in the shadow and know what a judge would do were you to proceed all the way to trial. Does adjudication encourage parties to work together or compromise? Yeah, I think it does for these two reasons that we've been talking about, right? First of all, a realistic prospect of adjudication is a threat and incentive to settle, to eliminate the risk of the worst case scenario, your terrible day in court. People are afraid of having a terrible day in court and having a judge give their opponent everything. So that fear leads people to the table, and then adjudication also creates a shadow of law, creates a legal certainty that lets people know what their rights are and settle on those without having to go to court. Now, arbitration, right? We know that arbitration is privatized judging. Arbitration is secret, right? If you have an arbitrator, then the reasons are generally not public. So arbitration is not quite so good from this point of view. The arbitration does not create any legal certainty for anyone other than the parties to the decision itself. The parties were not one of the settlement offers. Yeah, I mean, sometimes they do want to go straight to adjudication. The system doesn't like that. It's a very, very rare case where you know, if you have two lawyers who are not thinking about settlement and not talking about settlement, it's a very rare case in which those lawyers are doing right by their clients, because more than 9 times out of 10, the client's interest is in a negotiated resolution. What would the judge do when both sides refuse to settle? The judge would adjudicate, right? So ultimately, like, judges have various tools, and the rules give them various tools to try to encourage settlement. But ultimately, you don't have to settle, right? You have the right to bring your claim, assuming it's legally meritorious, and ultimately the system is going to have to adjudicate it if you don't settle. Okay, so this Rignac versus Malden case, it's about encouraging settlement, but it's about giving parties access to adjudication short of trial, because preserving a realistic possibility of adjudication improves the quality and quantity of settlements that we're going to get. And the trial process is not good enough, right? If adjudication matters, then the trial process is sort of our old ancient standby, but it's not good enough, right? The full trial has become largely illusory, because except when there's public money available, ordinary Canadians cannot afford to access the adjudication of civil disputes, right? We know it's $40,000 to $50,000 simply in one side legal fees to get a civil dispute up to the point of trial. And so if trial were the only source of type of adjudication we have, then we'd be scuppered, right? We would have no shadow of the law, and we would have no incentive to bring parties to the table. Okay, so it's all about proportionality, right? And that's this case is a very important statement of what proportionality is about. If the process is disproportionate to the nature of the dispute and the interests involved, then it will not achieve a fair and just result, because parties won't use it, right? If the only way to get adjudication is to go to trial, and every trial costs $50,000 and takes 2 years, then the whole trial mechanism will be irrelevant to any cases that are worth less than that. And so proportionality, we know already, I think we've read this already, is enshrined in the rules, right? So rules 1.04 and 1.1. And these are right at the outset in the kind of definitions and guiding principles section of the rules of civil procedure, which means you want to be thinking about proportionality when you're applying any of the rules or any of the common law precedents. And the Supreme Court, since they're talking about proportionality, they want to say not only is this in the rules, but it's also something that has to guide lawyers and judges. So for lawyers, and we talked about this in the legal profession class, counsel must, in accordance with the traditions of their profession, act in a way that facilitates rather than frustrates access to justice. Lawyers should consider their clients' limited means and the nature of their case and fashion proportionate means to achieve a fair and just result. So you are no longer practicing competently as a civil litigator if you simply drive your client down this road, not that road, this road, right? You can't be a good litigator and do that. You always have to be thinking about the shortcuts and about the settlement opportunities in particular. And it's tough for lawyers, right? Because we're trained to turn over every rock, and we see these great examples and these inspiring stories of lawyers who were absolutely indefatigable and turned over every rock until they found that piece of evidence that vindicated their client's rights. And the court here is saying, turn over the rocks unless and until turning them over is disproportionate and excessive. So it may sound like an impossible circle to square, but I mean, good lawyers do it. Okay, so that's proportionality for judges, for lawyers rather. They also talk about proportionality for judges. So what does this overarching principle mean to judges making decisions about procedure? So the process of adjudication must be fair and just. Obviously, that cannot be compromised. However, the trial process denies ordinary people the opportunity to have adjudication. Therefore, the best form for resolving a dispute is not always that with the most painstaking procedure. And she's talking about adjudication here, right? So she means different forms of adjudication. And among those different forms, the trial is not always king. Yeah, so it's the same idea there. Okay. So I broke the Riniak case into, oh yeah, I mean, people remember this from a couple weeks ago, right? This is another example of proportionality reflected in the rules of civil procedure. We have these different fora with different levels of procedure. And you know, the trade-off is that a small claims court is more likely to get it wrong. Small claims court, there's basically no discovery, there's no motions, and unless you believe that discovery and motions are completely useless and they're just invented to enrich lawyers, if you believe, that is to say, that discovery and motions do help get at the truth, then excluding them and telling litigants they can't use discovery and motions is going to mean more wrong decisions. But the alternative is a system which is completely disproportionate. So we are willing to accept a high chance of getting it wrong in order to preserve a system which is meaningful and useful for the disputes that people actually bring to it. Okay, so summary judgment, that's what this case is, the concrete legal context for Riniak versus Malden. And summary judgment, so it's a form of disposition without trial. And more specifically, it's substantive, evidence-based adjudication of a legal dispute at an early stage. Right? So it's substantive and evidence-based, and that distinguishes it from striking pleadings, right? Where we don't look at the evidence and we don't look at the real world. We with striking pleadings, we simply look at deficiencies within those pleadings themselves. By contrast, here we're getting into the evidence, but limited evidence, right? So we know that at trial, the parties have an unlimited right to lead evidence, right? If you're the plaintiff making your case at trial, you just keep on calling your witnesses for as long as you have witnesses with relevant evidence to give. You keep on putting exhibits as long as they're relevant exhibits. The other side has the right to cross-examine on all of them, and it can go, there's no official end date. It can go on in principle forever. Summary judgment, we're getting into evidence, but we are restricting our evidence in search of proportionality. Okay, so on a summary judgment motion under Rule 20, the court can say no, forget about it, go back on that road to the conventional civil action. Or the court can say, yes, we're granting you summary judgment, in which case your client can win completely. Or the court can also even say the other side wins completely, right? So any party can move for summary judgment, plaintiff, defendant, co-defendant, or whoever. But in so doing, you run the risk that the court will grant summary judgment to your adversary against you, and you will lose completely and forever, or of course the chance that they'll just deny summary judgment to everybody, and everybody has to go back on the conventional civil action road. So, so this summary judgment, it's the most flexible, but also the most complex of any of these 8 forms of disposition without trial. You have Rule 20. Can the court? Okay, so sua sponte would be on the court's own motion, and no, it will not grant summary judgment to anyone unless a party moves for summary judgment. Okay, so you have Rule 20, and it's a bit of a mess. It's not clearly drafted. It's as I said, like many rules, it's kind of got different layers that have been added to it over time, and it's sort of 3 or 4 different procedures all crammed into Rule 20. But the point of it, the overall idea of summary judgment, is to create access to adjudication, to evidence-based substantive adjudication, without necessitating going all the way to trial, right? And that's why Riniak versus Malden is basically saying, we like this, and the Rule 20 should be interpreted in a way that lets parties use summary judgment, achieve summary judgment more often. Okay, so so we'll go through this rule. I think first I'll just tell you a little bit about the facts in Riniak versus Malden. They're not that important. The case arose from a case of white-collar crime. Fred Malden was this rich American guy, and with a bunch of his rich buddies. They basically got fleeced by this bogus investment scam, which they say was run by Robert Riniak, a Canadian guy. So they sued Riniak for civil fraud, and Malden, the plaintiff, was the one who brought the summary judgment motion against Riniak. Right? So Riniak is the guy who they say ripped them off. The trial judge grants summary judgment against Riniak, but does not grant summary judgment against some of the other defendants, right? Because the plaintiffs say this is kind of a ring of shady Canadian investment dudes. So summary judgment was granted only against Riniak. The Ontario Court of Appeal upheld that decision, and it goes on to the Supreme Court of Canada. And okay, so let's look at the rule, but what this is about. So what I've done here is I've tried to break down summary judgment into these sort of 8 questions, right? What is summary judgment? Who brings summary judgment motions? Where do they bring summary judgment motions? Why do they do so? At when? Like at what point in the procedure is a summary judgment motion brought? What material do you use? How does the court respond to this motion? And finally, how does the court decide? Okay, so summary judgment. What the heck is this? Well, I've already said this basically, right? A motion for adjudication, disposition of a case or a part of a case. Another wrinkle of complexity, you can bring summary judgment with regard to only part of a civil dispute. And if you succeed, the rest of it will proceed on to trial. Based on evidence, the substantive merit of the case governed by Rule 20 in Ontario. Who? So both the plaintiff and defendant can move for summary judgment. Where? Okay, slow down. So it's available to both sides. Is the point of this? The plaintiff can move for the early victory, getting everything they want in the statement of claim. The defendant can move for summary judgment, which means rejecting the plaintiff's case permanently. Where? So in Ontario, this is all subject to Rule 20. Most other provinces have similar rules of some kind. Sometimes it goes under different names, but the idea is always there of summary judgment. Quebec does not. Why do we have summary judgment? Why do parties bring it? So it gets at substantive, evidence-based adjudication with a speedier, less expensive process than trial, right? And this is what Justice Karakstanis is emphasizing in Reniak versus Malden, is that we, as much as we love settlement, we can't get rid of public adjudication because, among other things, if we did, settlement wouldn't work anymore. People would not be incentivized to settle, and they would not have a zone of legal certainty in which to settle. So we need public adjudication. This is a way to get it more quickly and less expensively than trial. From your point of view as a lawyer, it gets you that relatively quick, cheap, and total win for your client. When, at what point, can you bring a summary judgment motion? So the plaintiff can move for summary judgment after, basically after the statement of defense is issued. Don't worry about the notice of motion piece for now. So you've got to give the defendant a chance to sort of give their side of the story before you can do this, except in very in unusual circumstances. The plaintiff can move for summary judgment with their statement of claim without notice. So these would be cases where the plaintiff's rights simply can never be vindicated unless they're upheld immediately. So they're suing over something that the defendant might destroy, or their litigation is about something that has to be granted now, or else there'll be no point in granting at any point in the future. So in those exceptional cases, you can actually move for summary judgment with your statement of claim. The defendant can do so at any point after delivering the statement of defense. Okay, with what materials, what documents do you prepare if you are bringing a summary judgment motion? So you always need a factum. You remember we looked at the rules around, we were in the motions unit, we looked at the materials for use on a motion. We saw that every motion requires a motion record. It's only the more complex motions that require a factum. The summary judgment is the epitome of a complex motion, so we definitely are going to want facta. You need supporting affidavit material or other evidence, right? So this is something which is really important about summary judgment. This is an evidence-based motion. It's not for parties to just rely on their pleadings. They have to actually bring the evidence forward. Usually that comes by affidavit, but as we'll see, there's other types of evidence that can be used here as well. So we've heard already about the different kinds of affidavit. Can anyone remind us what are the two different kinds of affidavit? We talked about a gold standard affidavit and then kind of a silver standard, not as good. Yeah, personal knowledge affidavits are the best. Affidavits on information belief are not as good. So here, the best affidavit, again, is that of a person having specific knowledge of the contested facts. And that's best. Information and belief, once again, is weaker evidence, and the court can draw an adverse inference, right? So if you come forward seeking summary judgment and you have not provided evidence from the parties who know the issues best, then the judge might infer from that your case is kind of weak and we're not going to give you summary judgment. And then for the responding party, so people hopefully remember the lingo here, right? So you start off with the plaintiff and defendants, and then once you get into motions, like a summary judgment motion, you have the moving party and the responding party. And the moving party can be the defendant or the plaintiff or a third party litigant. So the responding party means which did not seek summary judgment. And in responding, they have to show specific facts showing that there is a genuine issue requiring a trial. So this is because, so if summary judgment is refused, that means we're going to go on to trial. So the role of the defendant here is to say, we can't have summary judgment now. We need to have a trial, and these are the reasons why. we'll talk about what the court says about that in a second. Okay, so those are kind of the 6 W's of summary judgment. Then we have 2 H's. First of all, how does the court proceed? So what the court does depends on whether it is a dispute over law alone or whether there actually is a factual dispute between the parties. So if the parties are just arguing over a pure legal question, and you brought the motion before a judge, okay, so people, I should probably explain again, judges versus, have I talked about this? The difference between a judge and a master? Does that ring a bell? Okay, so Musa remembers. I don't know if other people, I'll just say it again. So a master is a junior judicial official who typically hears procedural disputes related to civil litigation. A judge is the full, you know what a judge is, right? Okay, so if you bring a motion before a judge, then the court can determine the question on the basis of the submitted materials. But if you bring that before a master, that's kind of like beyond the pay grade of a master to resolve issues of law alone. Then they have to kick it upstairs to a judge. People understand what's going on here, hopefully. So that's if it's just issues of law. If there are factual issues disputed, then it's a little bit different. If you bring it before a judge, and it's in the interest of justice to use the extra fact-finding powers. Okay, so what are these extra fact-finding powers? So these are things the judge can do to try to figure out the truth. Things that would normally only happen at trial, but techniques that can be used on some summary judgment motions if the test is met. And so these are these extra fact-finding powers. Weighing the evidence, which is to say you've got conflicting evidence on both sides, deciding what the truth is, evaluating the credibility of a deponent, deciding how much to trust this person who's giving you the evidence, and drawing reasonable inferences from the evidence, right? So these are all trial-like things. This is what a judge or a jury does at trial. They decide, well, who's lying? Who do I trust? What can I infer about reality from the evidence I've heard? But in the context of summary judgment, those are described as extra fact-finding powers. Then you can do all that if it's in the interest of justice, and you can order that oral evidence be presented. Again, like the touchstone of the trial is that that's where oral evidence is heard. But Rule 20.04 sub 2.2 lets that technique be brought into summary judgment as well. And this is makes it very exceptional as a motion, right? So usually on a motion, none of this is there. Most motions are, we have affidavit evidence, right? Or documentary evidence. This is a very special motion where we can bring these things in. But if you have sought summary judgment on a matter with factual disputes, and you brought it before a master, then or it's in the interest of justice for such powers to be exercised only at trial, then the court is going to assume that the evidence is true, but make no inferences from the evidence. Okay, so it's pretty complicated, right? Because the rule, even what evidence is going to be admissible, is kind of like a moving target that depends on whether these tests are passed or not. And what it comes down to is that these extra fact-finding powers and the hearing of oral evidence is not always going to be allowed at summary judgment. And Hriniak will tell us a little bit more about how to apply that test. So to answer Sarah's questions, sometimes it's not always the master will hear it first. Sometimes it'll be heard before a judge, like it's just assigned to a judge, or you request a judge when you bring the motion, and in that case, the judge will proceed. How is what decided? Sorry, how is it decided, master or judge? Okay, so this gets even more complicated. So some courts, like especially courts outside of Toronto and Ottawa, don't have masters at all, so it'd be only judges. In other cases, someone's assigned based on who's available, and still other cases, the parties have to request one or the other. You don't need to know that. You just need to know the bound of Rule 20, which make things depend on the presence of a master or a judge. Okay, so this is all about what happens if there's disputed factual issues on the summary judgment motion. And this slide is about when the court is willing to use these extra powers, because there's a reason not to, right? I mean, the problem with having the judge weigh the evidence and order the oral evidence be presented is that we lose what we liked about summary judgment in the first place, is it's quick and cheap, right? Summary judgment started off with just parties bringing affidavit documentary evidence. Documentary evidence is relatively cheap compared to having to actually line people up to testify in trial and prepping them and so on. So this business of oral evidence and extra fact-finding powers was brought in to make summary judgment more flexible, to let it resolve more cases, but the price of doing so is that it makes the whole thing less expensive and makes it less different from the trial. And this is supposed to be a meaningful alternative to trial. Okay, so Riniak, that's all in money, right? Riniak tells us more about this interest of justice business. When do we actually use these fact-finding powers? So first of all, if the court can decide whether or not there's a genuine issue requiring trial without using the extra fact-finding powers, then don't use them. Kind of obvious, right? We're trying to save time and money here. If we don't need to bring in all these extra bells and whistles, then we won't. Otherwise, consider proportionality, timeliness, and affordability. So how much more is it going to cost to use those tools? How much more time is it going to add? How much is at stake, right? How proportionate would it be to bring those in? And then do a comparison of the evidence that will be available at trial and on the motion, as well as the opportunity to fairly evaluate it. So this is kind of a matter of, like, the judge at this point should know what witnesses the parties are likely to call if it does go to trial, right? And then the judge is supposed to kind of predict, well, if we have that full trial, the full 9 yards, every party can call all the witnesses, submit all the exhibits, and do all the cross-examination that they want. How much are we going to know then versus how much we can know now at the summary judgment stage, right? And if those sets of knowledge are comparably large, then we should just resolve it now. But if there's lots of important things that may affect the just outcome, which would only come out at trial, then that kind of pushes us towards having the trial and denying the summary judgment. No, not necessarily, Jeremy. So for that, you'd want to refer back to the when slide. It can happen quite early before any discovery happens. Okay, so when a judge should order oral evidence on a summary judgment motion. So here, this is again, like, it goes with those extra fact-finding powers. The power should be employed when it allows the judge to reach a fair and just adjudication on the merits, and it is the proportionate course of action. So always balancing cost versus utility. How important it is to get, how much it will help us get it right. And if it would assist the motion judge in weighing the evidence, assessing the credibility, or drawing inferences. then in those circumstances, we should be willing to use that oral evidence tool. Yes, these are the extra fact-finding powers, but the judge has to decide whether to even use those extra fact-finding powers. So technically, the extra fact-finding powers are these things, right? Weighing the evidence, evaluating, but it's a similar set of considerations that go with oral evidence, right? Because all of this stuff is about like how many trial-like features should we bring into the summary judgment stage, right? And in both cases, for all of that, we're thinking about proportionality and how much is gained versus how much is lost by bringing that stuff into summary judgment. Okay, so that's the rule for how the court proceeds. Let's go on now to the eighth part of this, the second H. How does the court actually decide, right? So are we going to grant summary judgment or aren't we? Yes, the court can determine summary judgment without extra fact finding, right? Some summary judgment motions are resolved on the basis of that affidavit evidence alone. You always have to have the affidavit evidence. You always have to have the facta, and sometimes that's the basis upon which the motion will be decided. Okay. So what Jeremy says is not quite right. The court will determine summary judgment without extra fact finding unless it can't, in which we'll use. No. So some cases the court will say, okay, we can resolve this on the basis of only the affidavits and the facta. Great. We're going to grant summary judgment, or we're going to decline it. Sometimes the court will say, okay, we can't decide whether to grant summary judgment on that basis. Therefore, we're going to use the extra fact-finding powers and hear oral evidence. In still other cases, the court will say, okay, we can't decide on the basis of affidavits and facta, but we're not going to use those extra fact-finding powers because they cost a lot of money, and we think that even if we get that extra evidence now, we still won't have a good picture, and we'd still have to go to trial anyway. So we're just going to refuse summary judgment, right? Because you don't want to waste that time unless you think it's going to make the difference and let you get that proportionate result more quickly. Yeah, save money, go to trial anyways, right? Because that's the thing about summary judgment. I mean, it sounds great, right? Like, oh, public adjudication, we'll have it early. We won't have to spend so much money. But then you realize that this, from another point of view, is just another procedure which may fail, right? And in a case where a party brings a summary judgment motion and it's declined, then the whole civil action costs more and takes more time than it would have if no party had ever sought summary judgment, if we'd just gone straight to trial. So there's definitely some people who think that this is unnecessary, and we'd actually be saving everyone time if we just didn't have the possibility of this and we just went to trial. Okay, so summary judgment can be a waste of resources for sure if it doesn't succeed, and there is some material in RINIAC about how to salvage the resources, right? They talk about this at paragraph 74 of the judgment. Salvaging a failed summary judgment motion, right? Because it's a real bummer if the parties spend all this time and we don't even get a resolution for this. So you can do a few things here that they talk about. The court if they can't grant summary judgment, at least they know more about it, so they know more about the case. They can create a schedule for what's going to happen in the future to hopefully get to trial more quickly. The court may provide a restricted discovery plan, set a trial date. We won't get into what all these things mean, but they're all ways to kind of at least get some benefit from the fact that we had an unsuccessful summary judgment motion. Place limits on any oral examination of a witness at trial to be subject to a time limit, right? So, we let Joe Schmo come in and give his oral evidence at summary judgment. We've heard from Joe Schmo, so if you're going to call him at trial, Mr. Plaintiff, then he only gets half an hour, right? Because we've heard him already. We want to restrict the costs. And finally, there's also this idea of remaining seized, that where a motion judge dismisses a motion for summary judgment, in the absence of compelling reasons to the contrary, she should also seize herself of the matter as the trial judge, meaning that the judge who heard the summary judgment motion should also hear the trial. Because at least that way, the parties can skip some of the evidence because the judge has already heard it, and we'll save a little bit of time and money there. Okay, so right, I haven't done this last slide yet, have I? So how the court decides. So the court should grant summary judgment to either the moving or the responding party, right? Remembering that you can move for summary judgment, but you run the risk of summary judgment being granted against you. So the summary judgment being granted if there's no genuine issue requiring a trial, or if the parties have agreed to have summary judgment as final disposition instead of a trial. So sometimes the parties will say, look, we can't settle this. We need a judge to sort it out for us, but we don't want to spend the money to go to trial. So let's just both agree that summary judgment will be our final kick at the can. And the judge, if the parties have that agreement, will do so. They'll give it to either one side or the other. So that eliminates the possibility of going back on the road to trial. And the court, but even then, the court will only do it if satisfied that it's appropriate to grant summary judgment. If the evidence is so weak, they don't want to make a wrong, they don't want to get it completely wrong. So they might refuse to do that. I mean, the parties can always settle, but if the evidence is so weak that they can't, then they won't, even though both parties want them to. And then this is the salvaging business, right? If the motion is fully or partially refused, the court may make an order specifying the facts and the issues. So there it is. I hope this makes sense to people. It's the rule reflects a lot of competing goals, a lot of things that the drafters were trying to do, right? Like have this alternative route to adjudication, make it flexible enough to be able to handle a bunch of cases, but don't let it become so expensive and time consuming that it's effectively the same thing as a trial and no cheaper than a trial anyway. There will be no genuine issue requiring a trial when the judge is able to reach a fair and just determination on the merits of a motion for summary judgment. And that's when the process allows the judge to make the necessary findings of fact, allows the judge to apply the law to the facts, and is a proportionate, more expeditious, and less expensive means to achieve a just result, right? So that's Riniak's interpretation of this genuine issue requiring a trial test. Don't grant summary judgment unless all these things are true. I do want to talk about this case in the 5 minutes that remain. So this is a case which tells us a bit about the requirements for getting summary judgment, and also tells us something interesting about self-reps. So Sanzoni was a lady who visited a dentist, and she received what she considers deficient dental treatment from Schechter, the dentist, and so she sues Schechter, and she sues a couple of other dentists who were involved in treating her as well. The dentists moved for summary judgment, right? So they use the defendant's version of the summary judgment rule, and they win. The motion judge grants them summary judgment. And this is something that happens very, very often with self-represented litigants, right? So I think I mentioned the self-represented litigants project we have here at Windsor Law, led by Professor McFarlane. And they've done some interesting research on summary judgment motions, where they did a quantitative analysis of all the summary judgment motions brought against self-reps versus the motions brought against represented parties. And summary judgment is granted against self-reps at a very, very high rate. Now, some people would say that's because they don't know what they're doing, and they bring a lot of spurious claims, which are rightly subject to summary judgment. Others would say that that manifests the system's bias against self-reps. That's kind of a live debate, but I encourage you to check out the NSRLP's webpage. They've got an interesting piece on that. But anyway, so here, the represented defendants, the dentists, moved for summary judgment against the plaintiffs. It was granted. So a couple of important things in this case that we need to take away. First is at paragraph 21, where they talk about what do you do, right? How does procedural justice work when you have a represented party facing off against an unrepresented party, right? And we know that self-reps are more and more prevalent. The majority of family law cases have at least one self-rep, and it's probably 10, 20, 30% perhaps by now in other civil matters as well are self-reps. So fairness requires a judge to accommodate a self-represented party's unfamiliarity with the litigation process to enable her to present her case to the best of her ability. Right? So we already know rules are a little bit bendable, a little bit liberal. We're going to use that liberality to try to make sure that self-reps don't lose and don't have to sacrifice their legitimate legal rights simply because they don't understand this insanely complicated civil justice system we have. Of course, any accommodations made by a judge to a self-represented party must respect the rights of the other party. Right? So just as much as we're trying to help self-reps, it still can't be the case, or it's still wrong if you as a represented party end up having to spend more money on your lawyer or take more time to get to trial just because the other side is the self-rep, they don't get the rules, and the system is bending over backwards. Especially if maybe like you are digging deep into your retirement fund to pay your lawyer, and the self-rep is not. Like they think they can do it themselves, and they seem to be getting extra consideration. Right, so that's a tough circle to square for a judge, right? But this is both these are the law, and courts have to try to make that work. So in some cases, here the plaintiff has failed to come up with this expert evidence, right? If you're going to try to prove dental negligence, you need your own expert evidence from a dentist showing that what the defendants did was negligent. Plaintiff has not yet come up with that. We want to cut them some slack, but we also want to respect the rights of the defendants. And sometimes it's very tough to kind of square that circle. Here it's not, because the defendants have themselves failed to abide by one of the basic requirements of Rule 20. Right? You have to move with supporting affidavit material or other evidence. You have to bring new evidence. Whether you're a plaintiff or a defendant, if you're seeking summary judgment, relying on your pleadings is not good enough. Your pleadings have no evidence. And under the normal course, we're going to get the evidence out of discovery. Here, we're trying to take a shortcut around discovery and grant summary judgment, but it's a substantive evidence-based motion. And you have to bring that evidence. And the defendants just didn't do it. Right? They've their affidavits are crappy. They're from people in the firm. They haven't put their best foot forward. as is incumbent upon any party seeking summary judgment. So fortunately, the judge has like a relatively easy way to cut that self-rep plaintiff some slack, because the defendants have not come to court with clean hands, so to speak. They haven't put their best foot forward. Okay, so we didn't get to Rule 21 and 23, but hopefully on Thursday we will. Thanks for bearing with me through this complicated rule. I'll stick around and let me know if I can help clear anything up. Thanks, everybody.